What do we do?
I like to.
For an adjournment.
No, Your Honor. We like to set this matter for exam.
Okay. Discovery is complete.
It is, Your Honor.
Preliminary examination in person will be set July 15th. Bond will continue. Hang on a second. I don't know if we have a violation report.
I believe I received that today, Your Honor.
You did. Anything you want to say regarding this violation?
First of all, we'd like to apologize to the court and the prosecution for making representations that my client was clean. I just received a report today and I was going off the indications of my client, in which he apologized to me and he wants to apologize to this court.
I understand the apology, but he had, by telling you what he told you, he had you give certain representations to this court.
And believe me, we had a long discussion about that.
I'm sure you did.
We did. I believe my client maybe was embarrassed. I did, after discussing this with my client indicates to him that he did relapse. The stress of this case was helping him relapse. But he said one thing that really mattered. He said, it's not an excuse. And I understand that my client is taking accountability for this situation.
So he admits to this violation?
He admits to it, Your Honor.
All right. Go ahead.
I believe my client takes accountability for this situation. He really came to me and said, I'm really trying to straighten out. I believe there's better ways that addiction could be handled besides being in the confines of the county jail. My client suffers from an addiction. He suffers from that disease and he understands that he needs that help. And he actually indicates to me that he reached out and has been searching for help. He could tell you, I know Domino Farms was one of the places, correct?
Yes, sir.
And he was telling me other aspects, other avenues that he was looking at to get that help. We just ask that this court have leniency, and we're coming to beg your mercy on this matter, and ask that this court have leniency on my client, maybe even allow him in an inpatient treatment, Your Honor, instead of having them behind bars.
Last time we were here, we were going to set it for exam, and I had put the offer on the record that it was that if Mr. McEwen provided proof that he had undergone some treatment since the date of this offense, that he offered that misdemeanor, and Mr. McEwen had interrupted and said he'd been in treatment for 5 years. Mr. Bird later, we adjourned, and Mr. Bird later came to me to tell me what the proof was. And while I respect that Mr. McEwen represents that he was for some time clean, I believe that he needs some help from some sort of a program. And so I do not think at this time that he is able to comply with the bond conditions if he's not in a program.
Anything else you want to say?
I respectfully, Honor, I'm asking if there's any way possible that my client, if he does go to jail today, could he be released to some sort of inpatient treatment?
I will always sign an order that allows him to be released to treatment, but what he's not going to do is come before this court, violate our bond conditions, then lie to counsel, have that lie then go to the court and think that somehow or another he's going to get over on the system. It doesn't work that way, and it certainly doesn't work that way with me, all right? Because I know that if his circumstance, if he had told you the truth, Mr. Bird, you would have made sure to try to communicate in some way to this court, not only just in terms of your ethical obligations, but also just in terms of trying to make sure that the right thing gets done, because that's the way that you are. So I think he's let down a whole lot of people, most of all himself. So at this time, certainly I will entertain anything, but is to go before Judge Washington on the 15th, but in the interim, defendant's bond is revoked. He's remanded.